In the realm of criminal procedure, the prosecutor serves as the engine of the legal process.
The prosecutor as dominus litis. The Latin term dominus litis literally translates to master of the suit. In a criminal context, this means the prosecutor is the primary decision maker regarding the life cycle of a case. The power of choice. The prosecutor reviews the evidence gathered by the police and decides if there is a prima facie case, enough evidence to proceed. If the evidence is weak, they have the authority to decline prosecution. The architect of the case. They draft the charge sheet, which is the formal document accusing the individual of specific crimes. Administrative justice. For minor offenses, the prosecutor acts as a filter for the court system by allowing an admission of guilt fine. They determine if the offense is eligible for a fine and set the amount, allowing the accused to settle the matter without a full trial. Amendment of the charge sheet. The law recognizes that humans make mistakes and that evidence can change during a trial. The amendment rules act as a correction fluid for legal documents to ensure justice isn't derailed by technicalities. When can a charge sheet be changed? Only for simple corrections like typos or minor omissions, not for changing the substance of the charges. The law allows for the amendment of a charge sheet to ensure that the legal proceedings accurately reflect the facts of the case, preventing a person from being acquitted simply because of a clerical or technical error. The most common reason for an amendment occurs when there is a variance between the allegations and the evidence. This means that if the testimony provided in court differs from what was written in the original charge, such as a different date, location, or specific item involved, the prosecutor may ask the court to update the document to align with the truth revealed during the trial. Furthermore, amendments are necessary when essential allegations or particulars are omitted. If a prosecutor realizes that a vital component of the crime, such as the element of unlawfulness or a specific statutory requirement, was accidentally left out, they must insert it to ensure the charge is legally sound. Conversely, the court may permit the removal of words or particulars that ought to have been omitted. This happens when the charge sheet contains irrelevant information or surplusage that might confuse the legal issues or incorrectly describe the nature of the offense. Finally, the law provides a broad safety net by allowing for the correction of any other error in the charge. This covers everything from typographical mistakes and incorrect names to the wrong section of an act being cited. The guiding principle throughout this process is that an amendment should be granted as long as it does not prejudice the accused. In other words, as long as the change doesn't unfairly handicap the defendant's ability to prepare a defense, the court prioritizes the accuracy of the record over initial paperwork mistakes.